Hey everybody, super excited. It is August 22, 2024. New program of Biden. We finally have the application. We finally have the frequently asked questions. Federal Registrar. I'm so excited to finally be able to share with you information about this new program. Si está buscando video en español, tenemos otro en nuestra página. I want to be doing this video in English, and we're going over the new Biden parole program. Before we get started on the details of the program, I think it's easiest to understand who benefits when you know how the immigration system works. All right, so say someone comes to my office and they entered with a visa and they're married to a US citizen. We fill out the packets, we request an interview, we get an interview wherever the people live, and then we win the case, right? Pretty simple. Not all the time. We have to make sure that person is admissible to the country, but nonetheless, that's the gist of it. Now, if someone comes to our office and the first question we ask them is, how did you enter the country? And they say without inspection, through the desert, through the mountains, there's a whole different process. That process is you first fill out the I-130, proving the marriage to the spouse, could take 8 to 14 months to get that. Then you have to ask for a waiver because when you go back to your country of origin for the interview, you're going to have a bar. And so we submit that. We have to prove extreme hardship to the spouse. That takes 4 to 6 years, yes, to adjudicate. Then that gets approved. Then the final interview is in your home country. So we're talking 6, 7, 8 years down the road. You finally get to go to your interview, but you're scared to go because you think, what if they don't let me back? Those are the people that this program was created for. Those very individuals that have been living here in the country for longer than 10 years. They have a U.S. citizen spouse as of June 17, 2024. They enter without inspection. They have no disqualifying criminal history, and they merit a favorable decision. So, ladies and gentlemen, that's who this program is talking about. So if that is you, congratulations. This is pretty awesome, right? Instead of asking for the waiver, instead of waiting forever, instead of having to leave and go to a country you haven't been to in so long, you can now apply for this program and do it here. This program will give you what's called an I-94. They will literally give you a little sheet of paper. That's all we're going for here, folks. A little sheet of paper that says I-94 and has a date on it as if it's a date of entry. That then puts you in the same place as someone that has a legal entry, and we can apply for adjustment of status here within the country. Now, there are some individuals who might benefit from this program but might not still be able to become a permanent resident. If you've ever been to an attorney and they told you you're perm barred, you're C barred, you lived here for a year, you left, you came back without authorization, you have to wait in your country of origin for 10 years, none of that has changed. If anybody has ever told you you have a false claim of citizenship, you need the law to change. If anybody's ever told you because of that crime, you need the law to change, you're still in the same spot. This program, the big benefit is really going to those who are admissible to the country, don't have any other problems other than the unlawful entry. Now, if you do have those other problems, though, you still might be able to benefit from this program. What they're doing is they're saying, if you meet the criteria and merit a favorable decision, we will grant you the I-94. You can get a work permit for 3 years, a driver's license, a social security card, but after that, you go back to where you're at today. No status, no other benefits. It's really meant to benefit for those individuals who have to leave for the interview that can do it here instead. But some individuals who would not want to do an interview because you'll be denied still might be able to have a 3-year work permit. But they're very clear that it doesn't look like they're going to renew that program. All right. Questions, comments, concerns, as always, drop them down in the comments or give us a call, 602-910-4040. Now I'm going to go into the details. And as always, you can go to USCIS pages. They have a really great page here, Keeping Families Together, where it talks about the FAQs, the Federal Register notice. There's even a guide to how to fill out the form, like just super, super useful information. My presentation is really just going off of what they already have there. But I like to kind of boil it down. What you see here on this page, you can read. And again, it's why it takes me so long to do a video after something new comes out, because I read every single one of these, right? And they all have something here, boom, where it gets a lot more detailed information. on each different topic. So it sounds simple, but it can get complicated based on your past history. Mine that I created is to try to simplify it. We'll throw this up on the webpage as well, but let me get that up here so we can go through what I think is the most important parts for the community to know about this program. So of course we have the who qualifies. We went through that already. You're in the country without admission or parole. You've been here since June 17, 2014. Legally valid marriage of June 17, 2024. No disqualifying criminal history, and you're willing to submit to biometrics and a background check. Stepchildren are also included. They have to have been under 21 on the date of the announcement. They don't have the 10-year requirement, but nonetheless, they can still benefit if the step parent is a U.S. citizen. So that's also good for quite a few people. And we go over to here, just who's not eligible, we already talked about, and then goes into a little more detail. President United States without admission or parole. Quite simply, folks, you don't need, if you come with a visa, this program. You already have that benefit. Been continuously here since June 17, 2014. The word continuously is a legal word that doesn't mean permanently, right? So there could be small breaks. For instance, some of those people that might be C-barred, left to go to a funeral for a week or for 2 weeks. Just because you left doesn't mean you're ineligible for the program, but it probably does mean you're ineligible for adjustment of status. Have a legally valid marriage to a U.S. citizen on or before June 17, 2024. And if the person has passed away, if you had an approved I-130 or you file a I-360 within 2 years, you could still be eligible for the program. Now, a big kick in the gut. Boom! This one hurt. Criminal convictions, any felony convictions. And I live in the area of criminal immigration, so just this was a painful one to read. But if you have any felony conviction, you're disqualified from the program. If you have any of these misdemeanor convictions, which again, in Arizona, most of these are felonies anyways, but there are some that concern me, domestic violence being one, controlled substance offense, except for 30 grams or less of marijuana. The domestic violence one, it is still possible to get your residency. That's the frustrating part. Like, it's not a ground of inadmissibility. It could be a ground of removability. It is a ground of removability. It's not a ground of inadmissibility, but it is a ground that keeps you out of this program. I don't like that at all. Anybody with a DV conviction is still going to have to do the traditional process and go through consular processing. Not fun. All right. Other offenses. Anything else other than the felony and these listed here, other than minor traffic offenses, are going to be a rebuttable presumption that you should be denied. That's, I'm talking DUI, I'm talking shoplifting, anything that you have that you still can adjust. They're going to say, prove us harder. Talk about how long ago the conviction was, how old were you, all the stuff that we would use in a good deviation request, basically in a criminal case. They're saying explain what happened, explain why you don't do it anymore and why you're a good person now. So definitely not going to be guaranteed approval simply because it's not one of those convictions. Now we go to removal orders. Anyone, another heartbreaker, anyone with a prior removal order who was an executed order, which means they left the country, you left the country pursuant to that order and came back, you're in the same category as felonies. You're also ineligible to adjust status, but there is a case here where it says if you've been ordered removed, but you haven't left, an unexecuted order of removal, you can apply for this program. Rebuttable presumption as well, going to be tougher, going to have to prove the case more, but still possible, okay? Case by case determination. Let's talk about this one and why it's so important, folks. The DACA loss in federal court, one of the reasons was because Texas and other states said they're just giving this benefit to anybody that meets the qualifications. They're not doing an individualized analysis of each case. Now, to grant parole, the president has the authority, but he must do so on an individualized basis for a significant public benefit or urgent humanitarian reasons. Right? So what we're saying here is they're really extending their power here, the Biden administration, and they know that they have to do a case-by-case individual basis, and they know there will be a day in the future where they'll have to send over to a judge how many people they've denied. and they'll have to say, look, there's X many people that qualified, entered iwi, been here 10 years, married to a citizen, but because they didn't prove to us individually that they merit a favorable discretion, we still denied them. They're going to do that. There's going to be more denials than people think on these applications. That's why you really need to beef them up in terms of the discretion and positive equities, so you're not one of that's left out as a statistic in order to try to keep the case alive and win a lawsuit in the future. All right. What's the cost to apply? $585 for the United States government. And the newest thing is it's all online. Interesting. No paper files. You got to do it online and make it happen. If you're eligible, do it now, do it quick. I do anticipate there will be a lawsuit and hope that as many people that are eligible can apply, get in, and get approved before that happens. There's still a chance to win the lawsuit, as I described. I think they're going to go about doing that, handling it differently than they did DACA, and we will wait and see on that. But in the meantime, apply. Questions, comments, concerns, give us a call, 602-910-4040. It's definitely a new enough program that if you think you qualify, you have a prior removal order, you have a criminal case in the past, or think you might be inadmissible, give us a call, 602-910-4040. Take cases all over the country now with their office open in Florida as well as Arizona, but we can do telephonic, video, anywhere around the country or anywhere around the world. That's it, ladies and gentlemen. Best of luck to you if you're applying. Questions, comments, concerns, get a hold of us, 602-910-4040, or post a comment down here, and we're happy to respond as soon as we can. Thank you.